Ladies and gentlemen, welcome back to the Indie Zone. We have some breaking news. Judge Stephen J. Hippler has entered several orders on the immensely important motions in limine that were entertained by the court on that marathon day of hearings back on April 9th, 2025. This is simply to provide you with what the rulings are. I will circle back with more details later. Regarding the order on the defendant's motion in limine regarding make and model of suspect vehicle 1, where the defense sought an order precluding the state from referring to the vehicles depicted on the various surveillance videos as the same vehicle, i.e. suspect vehicle 1, and from asserting that suspect vehicle 1 is a 2014 to 2016 Hyundai Elantra, arguing that these are speculative conclusions that invade the province of the jury. The state responds it intends to elicit expert testimony establishing the vehicles are the same, and such testimony will neither be speculative nor otherwise improper. The defendant's motion in limine regarding make and model of suspect vehicle 1 is denied by Judge Hippler, and that is dated April 18th, 2025. Next, regarding the order on defendant's motion in limine regarding Limine Nolan and touch and contact DNA. This is an order on the defendant's motion in limine. The court here states defendant moves in limine to exclude the testimony of Limine Nolan, the lab manager with the Idaho State Police Forensic Services Laboratory, who was disclosed by the state to testify about touch DNA and the transfer of DNA generally, and more specifically, that the DNA located on the sheath was more likely the result of direct transfer. Defendant argues that Ms. Nolan's testimony, as well as any other testimony referencing the terms touch or contact DNA, or purporting to be an opinion about the means or mechanism, how the DNA ended up on the knife sheath, is irrelevant or impermissible under the Idaho Rules of Evidence. In a very long order here, if we go to the bottom, we find that based on the foregoing, the defendant's motion in limine regarding Limine Nolan and references to touch and contact DNA is granted in part, but also denied in part. We're going to come back and circle back and explain what that means. So the defense got a partial win there. Now, regarding the order on defendant's motion in limine as to witness identification by bushy eyebrows. This starts out DM, a roommate of the victims in this case, was the sole eyewitness to the intruder believed to have carried out the crimes at 1122 King Road during her interviews with law enforcement at the preliminary hearing in this matter. DM described the intruder as having bushy eyebrows. Defendant moved in limine to exclude any evidence at trial referencing bushy eyebrows, arguing DM's description is unreliable and therefore irrelevant and or barred by the Idaho Rules of Evidence and other legal grounds. The court here, based on the foregoing, defendant's motion in limine regarding witness identification by bushy eyebrows is also denied. So DM's statements are going to come in the case. Order on state's motion in limine regarding neuropsychological and psychiatric evidence. The state seeks to prohibit defendant from offering any testimony during the penalty phase in connection with his neuropsychological and psychiatric evaluations performed by his disclosed experts, Dr. Rachel Orr and Dr. Eileen Ryan. The state argues the proposed testimony falls outside the mental condition evidenced allowed by IC. This is a statute 18207. Another very, very long order by Judge Hippler. Based on the foregoing, the state's motion in limine is granted in part and reserved in part. So this is a partial ruling in favor of the state with certain evidence here to be determined at a later time. We will circle back with further details regarding these rulings. Until next time, this is Kathy. Thank you for joining us here today.